各位委員係
Members, welcome to the panel on Administration of Justice and Legal Services. I call the meeting to order. Information papers issued since the last meeting. Altogether, we issued 2 papers. Members, please note that the first paper relates to Hong Kong citizens being murdered in Taiwan, sparking a discussion on mutual legal assistance and fugitive order arrangements between Hong Kong and Taiwan. Ms. Dari Lee and Mr. Holden Chow submitted this paper to me on the 8th of May. The paper has been issued to members. Now, on this matter, do members agree to put it on the list of items for discussion? Do you wish to speak? Can you be succinct? Please, within 2 minutes. Thank you, Madam Chair. This is a joint letter sent by me and Ms. Dari Lee, and I want to emphasize that we are not discussing the substance of the case here, but it is very clearly spelled out in the letter because we do not have any MLA or fugitive order arrangements with Taiwan, and I'd like to have a policy discussion on the matter in the future. If members agree that it should be put on the list of outstanding items for discussion, all I want is to invite government officials to discuss this issue with us. I can report to members that a Hong Kong citizen was involved in the case of murder in Taiwan, and I discussed the matter with the Secretary for Justice because I also intended to have it listed on our list of outstanding items for discussion. Now, in relation to mutual legal assistance with Taiwan, the reply from the SJ is that they need to conduct further studies. So I agree that more time should be given. And when the Department of Justice has formed a view on the matter, it would be more conducive to our discussion here. But indeed, this case has sparked some concerns, especially the concern from this panel, because it falls exactly under our purview. So I will put it on the list of outstanding items for discussion, and I will follow up the matter with the Secretary for Justice on your behalf. The other paper is this. In relation to several instances of members of the public taking pictures in the courtroom when court proceedings were in progress, I personally am concerned about this as well. I immediately discussed with the DOJ as well as the judiciary to see whether we can have a discussion on the matter as soon as possible. And this today, from Deputy Chair Mr. Dennis Kwok and Mr. Alvin Yeung, we further received a joint paper. They would like to discuss the cases and the security measures in court buildings. Definitely, they fall under the purview of this panel. But according to the judiciary, their view is this. Well, because I'm interested in discussing this matter as well, because we had cases of pictures of jurors being taken and cases being taken in courtrooms. Now, the first point is, according to them, the court proceedings are still in progress, and second, it is a matter of the judiciary instead. So I'm reporting their views to you because as soon as the incidents arose, I already relayed our concerns to them. So, Mr. Dennis Kwok, please, 2 minutes. Madam Chair, Mr. Alvin Yeung and myself are very concerned about the recent incidents of some personnel taking pictures in courtrooms. They may be breaching the law, contempt of court, and also causing prejudice just or perverting the course of justice. Well, in fact, I called for tightened security measures in court buildings, and I understand that very stringent security measures have been put in place for the High Court. And I think the incidents touch on policy issues. For example, there are police officers in courtrooms, but I wonder if they are sufficient in number, because they are tasked to keep watch of the defendants, not to maintain order and prevent someone interrupting the court proceedings. So we need to have a policy discussion on the matter, and I hope that like last time, we can invite the judiciary to come and discuss this policy. Any other views, Mr. Horace Cheung? Well, I'm not opposed to their suggestion. Of course, if a member is concerned, they can raise the issue, but my take is this. Whether the court has a jurisdiction to deal with the matter, or whether the court has the resources to deal with the matter. Because in the past incidents, my take is that the court has already dealt with the issue. They have noticed the issue. So what is the point of the discussion? Is it really necessary, policy-wise, to deal with this issue? Well, as I mentioned just now, I have been discussing with them because I believe members would be interested in knowing more about their policy and security measures. And when I attended court, I also deliberately checked the security measures, and I understood that the measures were tightened. The handbags would be checked. Now, from their response, I understand that the court proceedings are still in progress. But apart from the sub judice point, if we are to discuss the security measures in general, I can further discuss it with the judiciary. I'm concerned about this as well, and in fact, I immediately invited them to come. Sorry, speaker's not coming through. It's about how we can prevent similar incidents from occurring. I think it's a policy issue. All right, so it will be dealt with. Like I said, it will be put on the list of outstanding items for discussion. And we can further discuss with them that without going into details of the case, whether we can have a discussion. We also receive another paper. Well, this paper hasn't been distributed to members because it's a very long one with a lot of details. In fact, a group of building owners gave us a submission jointly. In short, they would like the Law Society and Bar Association of Hong Kong to draft a code of practice to regulate the conduct of lawyers, solicitors, and barristers involved in cases of building management. A lot of names have been mentioned. I have not printed copies for you, but you can ask the Secretariat if you need to read the paper. Second, well, in relation to the points raised in the submission, they contain a lot of details, so it will be put on the list of outstanding items for discussion as well. Well, mostly the submission concerns grievances from owners' corporations in relation to the lawyers involved. And they questioned whether, because of their professional background, these lawyers tend to take matters to court easily. But I don't think it's appropriate to give you details of individual cases. So if you'd like to read the submission, you can get a copy from the Secretariat. And I may put it on the list of outstanding items for discussion. We may not reach that item within our term, but at least it will be put on the list. And, of course, we can also suggest that they go to the Duty Complaints Office as well. Well, on the whole, they would like to like us to review the policy. So it's kind of related to the panel. I will put it on the list. If there is no objection, let's move on to the agenda proper items for discussion at the next meeting. We have two paper. One CB bracket 41113/1718 bracket 01 as well as bracket 02 LC papers. List of outstanding items for discussion and list of matters for follow-up action. So list of outstanding items for discussion. Next meeting we're going to discuss training and legal education in Hong Kong, and also implementation of recommendations made by the Law Reform Commission, LRC, and the third item, LRC's consultation paper on miscellaneous sexual offences and consultation paper on periodical payments for future pecuniary loss in personal injury cases. Do we agree to the three items to be discussed at the next meeting? If there is no objection regarding legal education and training in Hong Kong, as we did in the past, of course, we are going to invite the relevant representatives from law schools in Hong Kong, the associations, and also student representatives to our meeting. And it is also hoped that at the next meeting, we can also invite the Standing Committee on Legal Education and Training for Students. They have compiled a report. I will try to invite them, and also the two legal professional bodies and their progress in following up on recommendations in the report. If there is no objection, in order to discuss all three items, the next meeting will be adjourned at 7, an extension by half an hour. We could adjourn early if we finish all the three items. Next item, proposed creation of 2 permanent posts of Principal Government Counsel in the Civil Division and Law Drafting Division of the Department of Justice. So let's invite the administration to come in.
The paper is 1113/1718 bracket 03 concerning the proposed creation of the 2 posts. Now, on this issue, if members would want to speak, would you please press the button and make that request known? All right. First of all, we will have the government representatives. Would that be Mr. Lee? Or rather Mr. Alan Seal, Director of Administration and Development, to bring us through the paper? Yes, Chair. This is a proposed creation of 2 permanent posts of Principal Government Counsel in the Civil Division and Law Drafting Division of the Department of Justice to cope with the substantial increase in workload arising from the increasing volume and complexity and scope of work. And the resources, in terms of human resources, had not been increased for a very long time. Now, first of all, let us talk about the PGC, that is Principal Government Counsel in Civil Division. And we only look at the number of cases. There had been 3 times in terms of cases handled by this department. And JR cases had increased from 2012, 557 cases to 2017, 903 cases, and that's a 600% increase. And there have been immigration-related cases and also other cases, including half of the cases being non-refoulement protection against torture under the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment cases. And since 1998, there had not been any increase in the PGC for civil litigation unit. We would want to have a new PGC in CLU, that is Civil Litigation Unit, to be responsible for cases in a number of areas, which would include personal injuries and medical discipline cases, and also other immigration-related cases, etc. And you can see from the paper that from 2006 to 2017, there had been increase of 60% in terms of the cases handled, and there had been no additional resources for this unit. And at the same time, for law drafting division, including some very mega drafting exercises, there had been more numerous and also more substantial than ever before. And that would include the co-location and also budget and tax-related measures, local legislation for national anthem law, etc. And in the next couple of years, there will be 2 mega drafting exercises, which include the one-stop electronic platform for trade to lodge business-to-government trade documents, as well as a corporate rescue procedure. And also the e-version of Hong Kong law, and also the Chinese English glossary of legal terms project. All these are very important projects, and therefore we believe that there should be a PDG for, that is a Principal Government Council, PGC, for Civil Division, that is CD, and the Law Drafting Division, that is LDD. And if this is approved, we'll bring this to the Financial Committee of the LegCo. Kwok Wing Hung and then Chung Kwok Pan. 5 minutes each, please. Can it be longer? Because, well, you want it to be longer? And yes, there is Chung Kwok Pan as well. That is fine. Let us have a full discussion. Now, I'm looking at the past 20 years. There had been a lot more civil cases. And I've asked a question before, and that is outsourcing of civil cases, the number, the barristers involved, and the chambers involved. We should make these information known because you're using public money. And these civil cases should be effectively and efficiently outsourced. For data, as I have mentioned, I do not know when the administration will be able to provide that information to us. Ms. Christina Chung, the law officer, civil law, please. Yes, indeed. That question or request had been raised by Mr. Kwok before, and we have used the meeting last time to compile the information because the information is voluminous in terms of cases, years. We did not have all the relevant information on hand. We had to gather such information, and that is why we are still preparing that compilation. What year can you go back to, please? Ms. Zhang, can you speak into the microphone, please? I'm sorry about that. Right. We are collecting 2 to 3 years of information concerning outsourced civil cases to outside barristers. So 2 to 3 financial years. What kind of information will you provide? The barristers, the chambers, and the sum concerned? Yes, along these lines, we will try to be as comprehensive as possible to meet with your request. Yes, for the DOJ position that is to be opened, I totally understand the need for that newly created post, but the legal profession would want to see the DOJ in outsourcing the civil cases to be more transparent in the entire process. In the UK, the 5 barristers who are most sought by the government, their names are disclosed. And this is nothing bad, of course, for them or for anyone. It is something that is should be transparent. And I would like to see that a time frame be given us by the administration to tell us when you'll be able to provide such information as mentioned just now. Now, as for the law drafting division, we understand the workload.
I understand the workload. I understand that the staff at the DOJ are working very hard, and the number of legislations and the complexity are going up. So we fully support the opening of the new position. And we actually thank you for dealing with all the private members' bill that we've been sending your way. So thank you for your work. And also the turnaround time is very impressive, even though the bills themselves are not easy. Especially, for example, our modern slavery bill or the special education bill that I propose is also been very professionally dealt with. So thank you. But 即係話返返嗰點咧，就係。
And going back to the point, the legal profession would very much want to see the numbers made public as soon as possible. Yes, the time frame. Can you answer that question, please? Thank you, Chair. Well, we are in a latter phase of work. I would believe in June we would be able to, as much as possible, provide as much of the information we can gather as possible. Thank you. Chung Kwok Pan. Thank you, Chair. I, of course, support the creation of these 2 permanent posts. But on the other hand, if you look at the figures for civil cases, if you look at 1998, 9,000 plus cases to now, 36,000 cases. We're talking about 300 to 400% increase. From 1998 till now, if there's not been any structural change to the department, and you're only creating 1 additional post, my question is that sufficient? I mean, if you're doing this, why don't you create a couple of more posts? Now, Mr. Kwok, my colleague just now, talked about outsourcing. Is outsourcing a more realistic way of going forward? I mean, if the workload is that voluminous. So that is for the CD position. Now, as for law drafting division, of course, I also am in support of the new posts. In particular, given the 2 mega drafting exercises, i.e. the corporate rescue procedure and also the trade single window. Now, this is very important also for the economic or business sector. And my question is 1 additional post sufficient, please? Ms. Cheung, please. Thank you, Chair. I would want to answer the first question first, and that is for is it sufficient to create only 1 principal government council post? I want to thank Mr. Chung for his concern. Yes, our work is indeed very voluminous, and it is over 30 years that we have not added any headcount. And we really look at the actual need before we come to the proposal to create this additional post. Now, for the proposal for this new post, it is really to handle civil cases, civil litigation cases. That is the focus this round. And for such cases, because they have been on the increase, and also in terms of management work to be undertaken by the PGC, which is squarely in his terms of reference, we believe that we should therefore create this position. As for other posts in the future, whether we need to create those for civil litigation, would it be PGC or would it be AGC or DGC? That is the 2 lower ranking positions, we will see. For example, if they are focused on their own unit's work and they are responsible to the PGC in providing their opinions to him, whether that is the appropriate way forward. We will look into that. As for your second question, whether outsourcing is a more feasible and effective way of going about it. Outsourcing, yes, because of the increase in litigation cases, there is that need indeed. We need, for instance, outside barristers where they have certain specialties and where they can help us in providing opinions. Yes, we will have outsourcing of cases. But what we want to do now is to create a position internally at a rather senior level. And his main work is to provide supervision and also at a high level to give a holistic view and supervision of the unit's work. So it is broad and deep, his work. And this cannot be helped or resolved through outsourcing of the work. And in particular, the person will have administrative and management roles as well, which is, of course, not delegable. So yes, we have outsourcing support, but that is external. Internally, we need internal duties to be done, including internal management and administration and also training and support. This kind of work will need a high level at PGC level. Chang Kwok-Kwan. Thank you, Chair. Following on Mr. Chung, my colleague's question, just some clarification on information. I'm looking at Annex 2 concerning the org chart and Annex 3 after the addition. Now, you're saying you want to segregate these two units. From one unit, they'll be split into two, and each will be headed by a PGC. But I also see that there is a DGC. My question is, at present, there are two such positions. Is that right? Are you saying that you are newly creating these two positions, please?
Let me explain that at the moment we have 4. Under the CLU, we have 4 Assistant Principal Government Counsel. And if we have another PGC, we're going to break it up into 2 teams. And under each PGC, there will be 2 DPGC, as well as the 4 APGC. It will be distributed under these teams. I'm asking about the Deputy Law Officer, DLO. Let me supplement. Regarding the DLO, that's the post title. And in fact, the post title is to be taken up by the PGC. So, all right, that's the same person. My next question is this. Well, I see from the paper in paragraphs 6 and 7, you explain the reason why these show that posts should be created. That has to do with a substantial surge in the number of civil litigation cases and a substantial increase of torture claims or non-refoulement claims. But can you explain, by creating these posts, how you can help address the reducing the backlog in regarding torture claims and civil litigation cases? Why do we need to, for example, create a post to oversee the work of another government council? Well, there has been a persistent increase over the past few years of cases because of the increase in backlog of cases. We have created more posts of government council, and on top of that, we also set up a dedicated team to tackle the non-refoulement claims. And if I remember correctly, in 2014, 2015, and I'm responding to the member's question. We created a D2 post or DL2 post. Now we propose to create another PGC post because of the surge in civil litigation cases, as well as torture claims and the workload arising from the torture claims, be it in the form of an advice or JR cases, such that a high-level principal of GC should be tasked to oversee it. And we do keep in view the demand, but on the whole, in terms of the strategy, whether a targeted approach should be taken, we need a directorate-grade staff to take care of the matter, and this is our suggestion. Next, my turn to ask a question. First of all, I would like to ask about paragraph 11 of the paper. Paragraph 11 refers to 5 teams under CLU and their respective areas of litigation work. Of course, there has been a substantial increase in workload. And then in paragraph 12, you mention the increase in the establishment from 42 to 81 from 2008 and 2018, but that the establishment of one PGC has remained unchanged since 1988. In principle, I support that you should increase your establishment, and I also accept your explanation given just now. You need to create this post to make high-level decisions. Now, apart from this post, just now some of the colleagues referred to outsourcing. But I've always have this impression that the DOJ is short of hands. Now, that's my impression. If this is not true, you really should review the division of work or efficiency of work. So can you tell us frankly whether you have sufficient manpower? Now, paragraph 9, that's a sensitive issue and it's really complex, from immigration, human rights, social policies, and it also has to do with the Secretary for Justice in the constitutional role, guardian of public interest. So from various angles, you need to deal with a lot of controversial and sensitive issues. So my first question is regarding the candidate, whether the candidate would possess relatively more experience in public law. And second question, with due respect, I need to talk about the collocation bill. I really find it easier to read the English text than the Chinese text. Well, we try to avoid it, but in fact, the English version was much easier to understand than the Chinese one. And in fact, there is a footnote, footnote 14, or footnote 15 on page 14 of the Chinese version, that plain language drafting means that even for Chinese text, it should be written in plain languages. Now, I need to declare my interest. Well, I sat on a committee of the commercial law for 7 years, and I understand that at the time there was a controversy surrounding whether we should use literal translation when we translated English text into Chinese. Well, we really need to make an improvement. We really need somebody who is familiar with English as well as Chinese laws. That may be the case for laws enacted long ago, but after 1997, at least the bills or the laws drafted in both languages should be more accessible to the public, to the ordinary readers. So for the new candidate, I wonder if you have given this any thought, or would you consider recruiting more professionals with this background? Ms. Zhang or Ms. Siu, would you please respond? Thank you, Madam Chair. The first point regarding manpower, I'm grateful to Mem Chair. I understand that you've been very concerned about whether we have sufficient manpower within the DOJ. Every year, we conduct a review. Well, internally, for example, apart from directorate grade, we also review the different ranks, GCs, SGCs, and also whether we forecast another major exercise will be coming. Litigation is, after all, projection. For other projects, we may be asked to give advice within a time frame. So within that period of time, we'll give a very serious consideration whether we have sufficient manpower. If it is not part of our standing work, we may ask for funding to create a time-limited post so as to ensure that we can provide the legal services being asked. And we do keep a very close view of the matter. May I continue? Yes. We can have a more relaxed speaking time limit. First, public law. Second, bilingual literacy. Yes, this is very important. We need candidate with knowledge and experience in this regard. So in terms of CLU, civil litigation, for example, if we are creating such a high-level post at a directorate rank to lead the unit, then yes, this candidate will need to possess knowledge in public law. At the same time, we also provide training to staff on a regular basis. We invite professionals every year, or at least once every 1.5 years, to explain the importance of public law to our new colleagues. So we do invite external parties and professionals to take part in our training. What about bilingualism? About Chinese law drafting, I'll invite the law draftman to respond.
Chair, for a question. Can I start at the outset by saying that the co-location bill is modelled on the Shenzhen Bay Port Bill ordinance, but also that, in fact, in relation to the PGC post sought, one of the primary reasons that will be of assistance to the Law Drafting Division is that it will allow time for somebody at that level to be involved in the refinement of a draft from the point of view of clarity and readability. At present, given the volume and workload, what tends to happen is that if a deputy law draftsman needs to prioritise, what they do is to prioritise the fact that the bill is legally effective, that it reflects the policy that's being asked for, and that the Chinese and the English versions match, so that there's no discrepancy of meaning between the two. It's hoped that with the introduction of a third post of deputy law draftsman, that in fact there'd be this opportunity for drafting refinement throughout the process, but also at the end. We have particular processes within the Law Drafting Division designed to deal with the Chinese text being as readable and as clear as possible, but I think that there is room for improvement, and this is where we are hopeful that the new post will bolster our resources in this regard.
Okay. As my time, actually, I don't have enough time. I will let Mr. Zhong to ask his second round, and then I will follow my question. Okay? 鍾國斌議員.
Good. Mr. Felix Zhong. Thank you, Madam Chair. I was going to ask about the translation between Chinese and English text, and last week I was scrutinizing the Inland Revenue No. 2 Amendment Bill relating to tax exemptions for performers. In the Chinese rendition, it said 表演者 in English means performer, an individual or a natural person. But according to the Law Drafting Division, the word in Chinese actually means a business entity as well. And there is also another Chinese term, 参与人, or in English, meaning participant. I feel that it was referring to a natural person, but then it also captures a corporation or an organization. So, in fact, there is a discrepancy between the Chinese and English terms. Because if we use Chinese, the character 者, it means only a person, a performer, not a performing group. And when I asked the question, the reply was that this is not unique to Hong Kong, because reference has been drawn to jurisdictions that use Chinese, and it carries the same meaning. Well, for jurisdictions, using Chinese in their laws, we're referring to mainland, PRC, as well as Taiwan. Because where else could we draw reference from? I gave 2 examples just now. In English, it's very clear, organization. But in Chinese, there is this character, 人, meaning person. So it's misleading. All right, I understand Mr. Zhong's concern. Ms. Johnson, or who would take the question? Deputy would take the question. Yes. Ms. Ma? Or Ms. Yip? Thank you, Madam Chair. Well, I haven't read the specific provision. Sorry, Ms. Yip, can you speak into the mic? All right. Is it better now? When we draft the bill, sometimes a more expeditious approach may be taken. Let's say in Cap 1, IGCO, it says that when we use the word person or 人 in Chinese, it also includes a business entity or an organization. So in many cases, we may find a particular term carrying this word in Chinese meaning person. And we wonder why this term would also include an organization. Well, if you look at this particular provision, that can apply to both a person or an organization, then it also includes an organization. Well, in fact, your colleague also explained that to me last time, but it really brings out an issue, Madam Chair. The discrepancy in the meaning in the Chinese and English versions, it is misleading.
Even though you're saying that in the interpretation, 人 actually includes company and person, but someone without legal background, such as myself, by reading it, I would not understand it as such. I would not also know how to go back to other materials and take reference and then understand that 人 to also mean company, or 者 also means company, because 者 in Chinese usually means the person. It would not be an entity, for instance, or a company performing, let's say, or singing a song, for instance. So this is not consistent between Chinese and English, as I've mentioned just now. And apart from China and Taiwan, what other jurisdictions will have Chinese legislation so that we can take some reference, please? Well, at present, it is indeed China, Taiwan, and Hong Kong that we take reference from. These jurisdictions will have Chinese legislation. And in doing so, we will be looking at terms. Certain terms in the respective jurisdictions may carry different meaning from what they are in Hong Kong. So taking reference, yes, but at the same time, we will have to take it into context as well. And in reading the law, whether in Chinese or English, our division tries to be as straightforward as possible in their drafting. And for Chinese and English internally, we have a project that is in preparation, and that is a glossary between Chinese and English for legal terms. And in this project, we will also be looking at the English versions to see whether translated into Chinese, it is easy for the layman to understand, for the people of Hong Kong without legal background? Or is there another way of saying it or drafting it so as to make it easier to grasp the meaning of and to understand? So these are some of the angles we would take in providing that kind of translation. Now, just to pursue the question that I put forward just now, and this is indeed an issue which has been an issue for the laymen as well as legal professionals. And that is, legal professionals usually refer to the English version of the law. My question is, when you draft a piece of legislation, and I would believe my understanding is correct, first of all, do I understand correctly that you would draft in English version and then you will translate it into Chinese? Now, the translator, I would want to ask you, what kind of ranking are these translators, and how good are they in understanding law and legal terms, or are they just translators? Now, declaration of interest, even though before the changeover of sovereignty, I had experience in translating from Chinese legislation in the mainland to English. And you mentioned just now the jurisdictions using Chinese legislation. I would want to point out that Macau is also one jurisdiction. And these are all mainland legal system jurisdictions, not common law jurisdictions. So for me at the time to have to translate the Chinese court's decisions into English and to make it understandable for common law practitioners, I had to understand both the continental law as well as common law. So my question is, what about your translators? What kind of background do they have? It cannot be that you can just draft a piece of legislation in English and then translate it into Chinese. And sometimes it's just, quite funny the way you translate it. As Mr. Zhong just now mentioned, Yan is a person. And it is a natural person, it seems, just by reading the legislation. And I've participated in the drafting of a lot of bills in columbarium, etc. We have to allow the ordinary person to be able to understand the law, not just the legal professionals. And for Chinese version of the legislation, I have a very formal request to put on the table here, and that is improve it. Maybe there are no other alternatives, and we therefore had to use the original translation into Chinese in certain circumstance, and it's just not satisfactory. And this is also applicable in other drafting experience as well. It's not just a columbarium legislation. There are many, many such cases where the Chinese translation is not satisfactory. So what is the process? Is it that you draft first in English and then the Chinese version is but a translation? And how do you improve on that work? Now, Chair, the reason perhaps is that in the past, there had been Chinese translation, and we had been drafting in English, and then the Chinese is a translation of the English draft. In the past, before 1997, there were translation officers who did that work of translation. But since then, it's been lawyers who have been doing the translation. And it was at a late stage that the lawyer translating the legislation or the draft bill would participate in the process. And the result becomes a translation. The Chinese becomes just a translation. Now, if in the workflow there is no change, then this kind of practice will be kept, and it becomes just a translation, the Chinese version. And in the past 2 to 3 years, what we have done as a change is to allow the lawyers doing the translation to participate early in the drafting process. And therefore, they can participate in an earlier process, a higher level. So they not only look at the English version, but in fact, the Chinese and the English drafting go hand in hand. So this lawyer who's responsible for the Chinese version as well, he is not a translator only. For instance, he would be cognizant that the format will have to be more or less the same. The Chinese and the English will have to be closely following each other in terms of format as well. And also, he will have to think whether it is very unnatural in drafting in English or in Chinese to follow very closely the English version. So the lawyer may actually go back to the main drafter and ask whether the English can be drafted in another way so that the Chinese can be more natural and its flow. So that also happens. And if we can have this time to do this, then the legislation would be a lot better when they come out. That's what I've noticed. But on the other hand, because of time, it is not always possible for the lawyer responsible for the Chinese version to participate early in the drafting process. There's another scenario, for example, for co-location. Indeed, it has referred to the Shenzhen Bay legislation, and it follows many parts of the ordinance concerned. And where there is this model to follow, we do not know whether there is flexibility for the Chinese version to deviate a little bit. For example, even for other legislation other than co-location, when we look at the Chinese version after the English drafting, and because there is a short history to Chinese translation, even now, looking back at some of the Chinese translation that's been done before, we would think perhaps there was another way of rendering the Chinese translation would have been better. And so we also ask ourselves whether we can deviate a little from the so-called blueprints or the models that had been done before in the Chinese translation. If we have that flexibility, there may be more improvement in the Chinese translation. Anybody want to ask a follow-up question? If not, then I would want to pursue with this line of questioning, because this is something that I'm very concerned about. And I also have another question in another area. Now, Ms. Fanny Ip was very clear just now. I think in the future you can refer to the Macau experience. They are also bilingual, from Portuguese legislation translated into Chinese. And when I look at the Chinese versions of their legislation in Macau, it seemed to be a lot more flowing and natural than ours. So you mentioned just now that lawyers who are bilingual do the translation. But what we need is lawyers. Well, there is actually a profession now, which is legal translation. You really have to strengthen your Chinese version. So this is a request right here for you. The Chinese cannot be a straightforward translation, because the Chinese and the English version of the legislation carry equal weighting, and therefore the Chinese version also has to be good. Now, concerning bilingual e-legislation, and we have actually discussed this last year in this panel, about how we use this website for bilingual legislation. The new version is indeed an improvement, but there are certain views raised, and that is, it's very difficult to print it out, because not only lawyers use this version, our assistants, legal assistants, lecture members, assistants also use this. And you have provided us a demonstration in a certain meeting before, and we've seen that. And some people feel that the old version was actually easier to use. As for the new version, there is a very specific opinion, and that is it's not very printable. So if you can go back and improve on it so that the ordinary user can use this version and find it good, and it's easier for the person to search for information on the website, and also if it can be more printable, that would be good. Is there any response concerning the e-legislation website? Ms. Johnson, please.
Thank you for that comment. In fact, we'll feed that back to the group responsible within the division. I could mention, though, that one of the enhancements that's to happen is for the PDF copies of the legislation, which are currently located at the bottom of the page, and I suspect that sometimes users are not scrolling down to that bottom of the page to see that there are PDF versions there, and that what they're seeing is a button called Print HTML and wondering what that is about. That there will be a change to the user interface to make it printing those copies more obvious and obviously easier.
Yeah, just make it more user-friendly. Okay?
That is our aim.
Yeah, it has been improving. The feedback is actually pretty positive, but we can do it better. Okay? 咁我諗呢就如果
Now, if there are no further questions concerning this agenda item, then I will have to put this to you. Are you in support of the administration for the proposed creation of 2 permanent posts of PGC and take this to the relevant committee? Yes, I believe there is support for this. Yes, indeed, yes. You can go forward with this. Thank you. Now, next we go to our next agenda item, which is a review of the damages for bereavement under the Fatal Accidents Ordinance Cap 22.
So let's invite the administration into the room and also other representatives, please. The relevant papers are CB bracket 4 1113/1718 bracket 04. The administration has provided a paper on the review of the amount of damages for bereavement under the Fatal Accidents Ordinance. CB bracket 3543/1718, a paper submitted by Mr. Ted Hui. It is a proposed resolution to amend the Fatal Accidents Ordinance. It is the President's letter on the matter. CB bracket 4 1113/1718 bracket 05, submission from the Law Society of Hong Kong. And also another paper, CB bracket 4 1139/1718 bracket 01, letter from the Hong Kong Federation of Insurers to the administration. So, for members who would like to speak, please press the button. Second, I will first invite the administration to speak, and then I will invite representatives of the Hong Kong Bar Association and the Hong Kong Federation of Insurers to speak. Thank you for coming. So let me first invite the administration, Ms. Lee Sao Kong, to speak. Thank you, Madam Chair. Good afternoon, members, according to the Fatal Accidents Ordinance, if a person dies because of a person's wrongful act, neglect, or default, which has caused the death of the deceased, the family members could claim for damages for bereavement. At the moment, the sum is set as $115,000. The amount was adjusted in 1997. Subsequently, because the cumulative inflation rate had continued to gone down, and it only went up to 1997 by March 2010, and in the interim, the statutory amount was not adjusted upward because the condition was not met, and in mid-2014, the administration commenced a review of the bereavement sum and made reference to the cumulative inflation as measured by the CPIA, and then proposed to increase the sum to $190,000. The DOJ also consulted the Law Society of Hong Kong and the Bar Association. The two bodies counter-proposed that the amount be adjusted to $250,000 on the ground that the increase should take into account not only inflation but also changing social and economic conditions of Hong Kong. In light of the counter-proposal, the DOJ considered how, if and whether and how the changing socio-economic conditions of Hong Kong should be quantified objectively, and the government economist was also consulted together with CNSD, and we considered that the economy encompasses a lot of different factors, including but not limited to population growth and structure, public health, housing, social welfare, crimes, social stability, economic growth, business performance, inflation, employment, earnings, and income. Therefore, there is no single indicator that can serve the purpose of expressing this concept. The DOJ has also studied the methodology adopted in other common law jurisdictions where statutory amounts of damages for bereavement are set, including England and some jurisdictions in Canada. And according to our study, these jurisdictions do not use changing social and economic conditions of the country as the criterion for adjusting the sum, because changing social and economic conditions in Hong Kong cannot be quantified in an objective manner. We considered it inappropriate to include the amount over and above inflation in the bereavement sum. On the other hand, we considered an objective and appropriate approach to make reference to the CPIA in reviewing the bereavement sum. In other words, we propose to increase the bereavement sum to $220,000 by the methodology mentioned above, which would be more than sufficient to cover the cumulative inflation reckoned from March 1997 to March 2018. The calculation of bereavement sum is set out in the annex of the paper submitted to the Legislative Council. With this objective and impartial mechanism, it is believed that the government can conduct a review of the bereavement sum once every 2 years. And the DOJ also consulted the two legal professional bodies as well as the Hong Kong Federation of Insurers. The Law Society of Hong Kong, in general, supports the upward adjustment of the bereavement sum on this occasion, and also the biennial review of the sum based on inflation rate changes. As for whether other factors should be reflected, they will follow up with the DOJ separately. I understand that the Hong Kong Federation of Insurers are also in support of the government's proposal. And we have a representative from the Federation today. I believe they will explain their position further. We also have a representative from the Hong Kong Bar Association in today's meeting. So that concludes my presentation. I urge members to support the government's proposal so that within this legislative year, we can move a resolution as soon as possible to adjust the relevant sum. Thank you. Thank you, Ms. Lee. Next, may I invite the representative of Hong Kong Bar Association, Mr. Nicholas Perry, to speak.
Chairman, we support the proposal. We are also very glad that they acceded and agreed to our suggestion that there should be an automatic review built into the legislation so that there can then just be a resolution of the Legislative Council in future. We've waited since 1997 for this uplift, and we hope this mechanism will make it much easier to do in future. So that's the Bar Association position. Thank you.
好，咁咧就
Next, from the Hong Kong Federation of Insurers, Mr. Eric Hui. Deputy Chairman, Hong Kong Federation of Insurers, Mr. Hui. Thank you, Madam Chair. We read the paper and we consulted the views of members. We give unanimous support to the proposal. Well, the bereavement sum will be increased, and as a result, some insurers may adjust the policy premium accordingly. Mr. Kwan, anything to add? Just to add to Mr. Hui's point, the Federation gives in principle support to the proposal, but we should note that starting from 2018, within the insurance industry, costs have escalated from the lawyers' fees to the fees and charges in government hospitals. All these have added to the burden of our industry. All right, I'll open the floor for members to ask questions. 4 members, each will be given 5 minutes. If necessary, I will relax the speaking time limit. The first to speak, well, let me read it out. The names: Mr. Holden Chow, Mr. Ted Hui, Dr. Junius Ho, and myself. 4 members. Starting with Mr. Holden Chow. Thank you, Madam Chair. Of course, we have different professional bodies here, especially the Hong Kong Bar Association and also the Law Society, which comes with a submission. And they all agree that the government should increase the bereavement sum from $150,000 to $220,000 because, according to the paper, the amount hasn't been adjusted since 1997. So this, at least on this occasion, we can catch up with inflation changes. I agree and I support this change, and I hope that, as mentioned in the paper, within this legislative year, the government can move a resolution to increase the sum. I would also like to make a comment. In fact, this is also mentioned in the submission of the Hong Kong Law Society. They ask whether a more comprehensive review can be conducted in the future. In fact, the government has undertaken on this occasion that a review will be conducted once every 2 years in light of inflation changes, and we welcome that. But I think the more comprehensive review should be conducted not just based on change in inflation rate, but in light of the circumstances then. And I'd like to seek the views of the government. Is there any response, Ms. Lee? Thank you, Mr. Chow, for your comment. About the comprehensive review to be conducted once every 6 years, the government's position is that we have given an undertaking that a review of the bereavement sum will be conducted by making reference to the CPIA every 2 years. As for other factors, in 2014, after receiving submissions from the 2 legal professional bodies, we made an effort to explore whether the changing social and economic conditions of Hong Kong could be quantified objectively. We found that it is a very difficult task. So the question is how we can quantify this, and there seems to be a lack of objectivity. We also studied the methodology adopted in the UK and Canada, which have similar statutory amounts of damages for bereavement, and to our understanding, the amount is also adjusted according to inflation. So without a more objective methodology to quantify the factor mentioned, we find it very difficult at this stage, and very difficult indeed, to come up with a concrete proposal. Thank you. So according to the government, at this stage, you're not able to come up with a proposal. But according to the Law Society, I understand that the so-called comprehensive review to be conducted once every 6 years, the Law Society will be submitting another written submission in due course. So I don't know whether you will consider the Law Society's view before finalizing your proposal. It may be a bit premature at this stage. You talked about lack of objective factors, but at this stage we haven't heard from the Law Society on this matter yet. So perhaps we should wait for their written submission to see if we can discuss more comprehensively on the review arrangement. Mr. Ted Hui. Thank you, Madam Chair. Thank you for arranging for this item to be discussed in a short period of time, and thank you for heeding my request to discuss this item of damages for bereavement under the FAO, because I noticed that in recent years we have had a number of tragedies involving, say, the collision of vessels near Lama Island, the Taipo bus accidents, and also the staff of Hong Kong Electric falling into the pit, and all these involved a person's wrongful acts. And according to the previous authorities, it seems that it seems that the Fatal Accidents Ordinance is often invoked, so it is a rather common mechanism. Of course, the grief of family members of the deceased in an accident can never be compensated by damages, but the mechanism provides a statutory amount, and in previous cases, I understand that because of the statutory amount of damages for bereavement, family members could get in the past $150,000 for, say, arranging for funeral service or paying for lawyers. In fact, this offered much help to the families. So I support the increase to $220,000.
This is but a minor legal amendment, but I want to criticize the administration or the government. In their process of review, the response that they gave and also the methodology, well, what was it like? It was in March, actually March 26. In that meeting, I have raised this as an issue. And at the time, it was an open meeting, and the administration knew that I was about to raise this, and there was no response from the administration whatsoever. And in the House Committee, on the 9th of May, I have raised this as a motion to increase to 220,000 from 150,000. And the government dared to write in after that to oppose this, to say that I have not consulted the Legislative Council panel on legal services. I would want to know why the administration had not referred to the meeting in March, wherein I raised this as an issue. Why did you oppose this in the beginning when you're saying that you want to amend this to 220,000 now? You have done nothing in the past over 20 years. You have consulted the specialist, and now and you see that it is supported, and you now change it. But why did you object to it when I raised it? And in raising it from 70,000 to 150,000 back then, it was said that in the future we will review this once every 2 years, this bereavement sum. Now, my question is, if that was what the administration said at the time when there was an amendment in 1997, why was there no revision once every 2 years for all those people who had been denied the payment of these damages? How can you face up to them? And how come you're able to come up with this proposal in such a short time to the panel? Explain yourself. Well, Chair, we are not singling anybody out, definitely not Mr. Ho. And actually, we have explained ourselves when we made the motion that this pertains to public money of the Hong Kong SAR government. And therefore, because it has to be Cap 31(1), the CE of Hong Kong SAR will have to agree to this before we can raise this as a motion. And the government, in proposing any motion, we first consult the panels relevant. And therefore, we believe that this topic should also be brought to the panel for discussion. And therefore, this meeting, we're discussing this exactly in this panel. And Mr. Hui said that there's not been any work in the past 20 years. Well, as I have mentioned, from 1997 March to 2010, during that interim years, the CPI had been downward developing. So there was no basis for an upward revision. And it was in 2013 that it had gone back to 1997 levels. And that's why in 2014 we have started the revision process. We have consulted the two legal bodies, the Law Society and the Bar Association. We have also discussed with the internal specialists within the government. And we found that it is difficult to quantify with any other methodology, and therefore we have come back to this panel today, and we think that is suitable and appropriate. Chair, you raise this as a issue. That is correct, Chair. Now, you have wasted time in the past, and when a legislative member raises this as a motion in the House Committee, and you therefore followed up, and you would not admit that you have done nothing in the past 20 years, this is an erroneous way of going about things. But we will not go to history. Now you're putting it in black and white that there will be reference to the CPI every 2 years for review. Now, my suggestion is a review should not only take into account the CPI, but also a more comprehensive economic and social conditions. I urge that this be taken into account in the future. Mr. Ho Kwon Yew. Next. Chair, I also believe that this amendment is a late come spring, but late is better than never. in the past 21 years, there had not been any specific review on the basis of adjustment. It is time that we do so. The CPI adjustment is just a minor amendment or adjustment, and it really does not compensate the relatives and family for any death. Now, we should look at the 1986 experience. How did we come by the $40,000? Now, this pain of the relatives of the deceased, it is not a short-term thing. There are a lot of, how shall I put it, there can be continued pain. For instance, for the entire life of the surviving spouse, let's say, or the family members who are very young, it's a long life that they will have to exist without the deceased family member. And this continuous pain is a very grievous pain indeed. Have you thought about that? And also, this deceased person may be a pillar of, or the breadwinner of the family. I think these should also be taken into account. In the next round of comprehensive review of bereavement sum, there should be a weighted, these factors should also weigh in. Now, you would know that in the past, the world was such that there were 4 to 5 members to a family, but now it is a much smaller family. And in the past, with losing one person, you at least have 3 to 4 people in supporting the family, and the pain would not be as much. But for a 3-person family to lose one member, the impact is so big for the family. So the pain is not that instantaneous pain at the point of disease of the family member, but it goes on for a long time. Even in raising it to $220,000 for a life, it is low. It's been 30 years since 1986, from $40,000 raised to $220,000. I mean, it should increase by 10 times or 8 times at least. Look at the property prices. Well, as for the two legal bodies, they, well, came to us or came to the government early on in the earlier years, and the government had come back with 220,000, and I think they are of the opinion, and I am of the opinion, that we will pocket it, quote unquote, for the time being. But I think it should be higher than this. The starting point was $40,000, and the ex gratia payment for removal was 1.2 million, really. So it is not just taking reference from CPI, but it is also about the family, it is also about human feelings. So I take these 2 points forward to you. Ms. Lee. Perhaps I can provide some information for members. At present, for instance, if there is a deceased person, deceased because of wrongful act of a person or neglect or default, this bereavement, damages for bereavement under fatal accidents ordinance, there is another leg, and that is for the family members or children of this deceased persons, if they rely on this deceased person for their livelihood. And for example, if there are loss of accumulated wealth, and where there are further medical expenses or funeral and burial expenses, all these can be compensated individually and separately. So to a certain extent, what Mr. Ho mentioned just now, where the family members sustain economic loss because of the disease of a family member, I'm pointing out that there are other methods, other ways of providing compensation to the family members under these circumstances. As for the Law Reform Commission in the 1980s, when they came up with this bereavement sum, it was really to compensate for loss and for pain felt by family members. We all know that life is precious. Whatever the compensation level, it is not sufficient to compensate the pain of family members. But this is nevertheless a legal compensation. Hopefully, in a certain way, it can compensate for the loss. And at the time, different jurisdictions' practice was referred to, and the level of payment was $40,000, which was arrived at in 1986. And from then on, it had been adjusted by taking into account the CPI, and in 1997, it rose significantly. Now, why do we have a statutory bereavement sum? And why doesn't the court make that decision? It is because if we do not have a statutory sum, but rather leave it to the court in every case to decide what is a sufficient amount to compensate for family members' loss and bereavement, it will be very onerous for the courts to examine and decide on the relationship among the family members, and that would not be a good way forward. Well, as for me, I would think this time the government will have to admit that they have been not in their best in handling this bereavement payment. You don't have to explain away for people who have gone before you, Ms. Lee and others. In the past 20 years, there had not been any adjustment, and that is not right. I'm familiar with the mainland compensation for the economic takeoff in the past 20 years in the mainland. In handling compensation, it was $200,000 per life. And we thought that that was insufficient. But because the standard of living in the mainland was very different, much lower than that of Hong Kong, and on March 22nd, I have to acknowledge Mr. Hui Chi-fung in his contribution. The first email was on March 22, and I was copied on the email as chair of this panel. And I saw his email, and I took notice of this issue, and I found that it was a very low 150,000 Hong Kong dollars, even lower than that of the mainland.
So I make a decision on the 26th of March very quickly that this matter should be discussed by the panel. And I do have a question for the insurance industry. You said you would go back and review, but frankly, of course, inflation is an indicator. Of course, I would support an increase in the amount, because if I didn't, there wouldn't even be an increase. But the question is, it's been 20 years, and we're just increasing the amount to 220,000. So what is the problem with the insurance industry? I'd like to get a better understanding. So I'll invite the representative to speak. And also, may I say that a private member's bill is more difficult than a government bill. But of course, if the bill is to be proposed by Mr. Ted Hui, members in principle would support it. I don't know how you're going to follow up on the matter. I mean, if the government is aware that something is missing and something needs to be done, then the government will take this forward. And this happened in the past as well. And very fortunately, members have raised this issue, and in fact, we should review the amount. Well, in 1985, you talked about discussion with the two legal professional bodies. I don't think this is an excuse, especially for those who would like to follow up on the matter. I am not the one following up on the matter, but if you say that the delay of the review had to do with submissions from the legal professional bodies, that is not a good excuse. Now, if you do not have sufficient manpower, I say once again that you should address the issue to make sure that an omission like this will not happen. Now, Mr. Ted Hui raised this issue. We have had a discussion today. I'm going to give time to the insurance representative to speak, but I also need to speak on this. I just received a motion moved by Mr. Holden Chow and seconded by Mr. Horace Cheung. Is a motion moved without notice on this point. That is to urge the administration to move a resolution within this legislative year to implement the adjustment. I'm going to distribute this motion to members. If other members would like to move a motion now, please give it to me now, and towards the end of the meeting we will deal with these motions. Well, it's about making improvements to the existing mechanism. That is $220,000, and I'm even suggesting that we should think out of the box, because $220,000 aren't really sufficient. So, insurance industry's representative, what is the reason? I'll try to take your question with Mr. Kwan. Over the years, the insurance industry has followed the statutory mechanism to fulfill the function of social protection, and we follow the legal requirements. We support the increase as well. Of course, the extent of the increase will have to be decided by members. In principle, we support it, and there is no consideration of the amount of increase. Well, but are you in a passive role? Is it that the government make a proposal and you just agree or disagree very passively? Or would you think that now it's 2018, whether there is a chance to make a further increase? Well, I don't think it is appropriate to pass comment at this meeting, but I can say that the insurance industry has all along been considering social changes and legal changes and following the law. And indeed, recent court rulings have posed a greater burden on the shoulders of the insurance industry. I can only say that we try our best to cope with social and legal changes. As for the statutory amount, that really depends on the views of members. Next, two more members would like to speak for the first round. Dr. Fernando Zhang. I'm sorry, it should be Mr. Ray Chan. Thank you, Madam Chair. Of course, I support adjusting the amount of damages for bereavement. And I think there is still room to further adjust the amount upward. I have this question for the government. Now, regarding family members of the deceased, whether they are entitled to damages, well, different family members might have difficulties, and I reckon the government would understand what I'm getting at. Because for the definition of family under FAO, say, wife, about this definition of wife, according to the ordinance, say if the husband marries a wife in a polygamous country or a country that allows polygamous relationship, then the wife will still be able to get the damages. And I understand the spirit of the law. The person has passed away, and the more relaxed approach should be taken so that family members would be able to get the damages. Now, what about couples married in another jurisdiction, will they be protected under the FAO? For example, in Hong Kong, we have monogamy instead of polygamy. What about other countries? If that is the case, what about same-sex couples married in another jurisdiction? Will they be covered under the FAO? I also understand that there is another provision in the ordinance, the concept of dependent. That is to say, the person living with the deceased for 2 years in a kind of husband and wife relationship. And if that is the case, it is covered by Section 4.2e. But let's say in a matrimonial relationship, even if the two persons do not live together, then the family member will still be eligible for damages. So I'd like to ask the government their position on same-sex married couples. Now, at the moment, we have 2 cases pending appeal, and the government so far has lost in these cases. So when you put forward an amendment bill, you need to clarify these relationships. Ms. Lee, or who else would like to respond to that? Ms. Lee? We will look into that in due course. But reading the provisions, it says husband, wife. So it depends on the actual relationships. No, Madam Chair, I'm not expecting her to answer me like this. Well, if the government cannot provide a clear answer today, then please supplement an answer in writing later. Let me ask again. Say, in a polygamous relationship not recognized by the laws of Hong Kong, are they protected or are they covered under the FAO? Ms. Lee, I can only say that as far as the ordinance is concerned, it says husband, wife. So the question is whether they are in a relationship of husband and wife. As for the details, I'll need to look into that later.
Follow any issue? No more? 你仲跟唔跟進?
Do you want to follow up on any issue? Well, the government is totally shunning the issue. I asked about the second wife in the polygamous relationship, and the government refuses to answer me. They just repeat husband and wife. Well, Mr. Ray Chan, it has to do with the matrimonial ordinance, and I think we have experience in reading bills. But because this is one of the very few ordinances in which matrimonial relationships not recognized in Hong Kong will be covered. Well, I think they're unable to respond to you at this stage. Maybe she's afraid she might said something wrong. Right. The sum, yes, we're talking about the bereavement sum. I don't think she's prepared to talk about marriage reform, etc. with you. So regarding your comment, I think there is still an opportunity. If you want to express a comment, yes, you can. But it also touches on their view on different provisions. Now, I understand their position, but I am asking about whether the second wife in the polygamous relationship could be entitled to damages, and they can't even answer me that. Will you be able to answer that? That depends on whether the person is the wife. All right? It depends on whether it's husband and wife. Well, you know that this is really a long-standing issue. Well, why don't we let Dr. Fernando Zhang finish his first round of speech, and then Mr. Piri would like to express his views as well. Following that, we have Mr. Ted Hui for the second round. We have time today. I'll try to let everybody express their views. Dr. Fernando Cheung isn't here. I'll invite Mr. Piri to speak first.
Yes, Madam Chairman, thank you. As a matter of information, I sat on the Damages Law Reform Commission in 1986. So that you know what we're dealing with, there was originally an award for loss of expectation of life which went to the estate. That was abolished in favour of damages for bereavement following Commonwealth practice. So that was the nature of the change. And it's only been a matter of CPI adjustment basically since then, since the damages levels have gone up. So that's the first question. What the value of a life in 1986 compared with today is a difficult question, and that is the one that the legal department have been dancing around. And it's not an easy question to solve. The second thing you should know before the members are too critical of the current system, we have a much wider definition of dependant in Hong Kong, so that it would include an estranged wife who still received money from her husband. There's been a recent case about that in which Mr. Justice Buwani awarded very substantial damages to a wife who lived in the United States and the husband that lived here. So then there comes the question of children. We have a much wider definition of dependent children than most Commonwealth jurisdictions. They include illegitimate children. So if you're dealing with a husband who has a wife in China and a wife here, this used to be very common practice, perhaps less so today, I don't know, but in the reported cases there were often those situations. The courts looked to provide protection for the children rather than the individual, the second wife. And that always produces problems, particularly if the first wife doesn't know the second wife exists. There's an argument in court about who should get the damages. So the second wife or the not legally recognized wife always produces a problem which is not easy to solve, and so the courts haven't really dealt with that issue specifically, save so far as the children are concerned. So I think it would be very difficult to enforce other countries' jurisdictions here, and it produces huge problems when both wives turn up at court. I've had that personal experience myself. And it's not a matter that can really be solved by legislation. So I think the learned member should really look at the ordinance and compare with what the ordinance says in the United Kingdom or in Australia or New Zealand, because the fatal accidents acts there are very limited compared with ours. We specifically widened it, for example, to include godchildren as well if they were dependent. So I would invite you to look at the definitions of dependent under that ordinance. They're much wider than in most jurisdictions. I hope that gives some light to the learned member's concerns, but it'd be very difficult to solve in legislation dealing with relationships which are not legally defined according to Hong Kong law.
好多謝 Mr. Piri。我相信呢一個問題呢。
Thank you, Mr. Piri. Now, first of all, we have to look at the legislation and look at case laws. There would be a lot of legal principles therein. It is not a new issue, and therefore we would have certain cases that we can refer to. And today, we will focus on the payment, and that is the amount of damages. When we talk about other related issues, perhaps it will take 3 days and 3 nights of discussion, and we certainly do not have that time in this meeting. So let us do focus on the topic on hand, which is to review the amount of damages for bereavement. Ho Chi-Fong, second round. Yes, just to respond on the discussion just now, if we look at the Fatal Accidents Ordinance 4(5), the design of the ordinance is such that the members of the LegCo can amend 4(3), and that is the amount itself. And in fact, on the 9th of May, the House Committee was not a private member's bill, but an ordinary member's bill, because I know that the damages are not paid out by the government, so theoretically it would not be relevant to government charging effect under the basic law. That is the first point. So it is not to say that because it's more difficult to have a member's bill and therefore the government should take it up. That's not true. Now, Chow Ho-Ding Chow also want to expedite this process. Hopefully, we'll be able to pass this in this legislative year. And I, on the 13th of June, in the LegCo House Committee, I will raise this resolution to increase the damages for bereavement to $220,000 from $150,000. I will be doing this. If you want to follow suit, then I welcome that. So my question to the government is whether you will raise this on June 13th meeting of the LegCo. We will do that as soon as possible. Chair. All right, noted. Next, Ho-Ding Chow. Second round. Is that right? Is that the second round? Yes. All right. Maximum 3 minutes because we have a motion to handle. We need time to handle that. Ho-Ding Chow, please. Thank you, Chair. As mentioned or announced by the Chair just now, I have a motion tabled, and that is basically to urge the government to, within the legislative year, to propose this motion so as to increase the damages for bereavement from $150,000 to $220,000. Hopefully, the people of Hong Kong can be helped through that. And would you please do that as soon as possible within this legislative year? Now, the second point, the reason why I raise this motion is also because I have heard very carefully Mr. Ho, my colleague's account of how he came up with the motion and also in raising the topic in the first place and how the government responded to his suggestion, etc. I would want to clarify certain procedures, even though it is true that Mr. Ho had raised the proposal and the consideration to increase the damages for bereavement. But Chair, you have also made the decision to, on today's meeting, to do a much deeper discussion on the proposal raised by Mr. Ho, and perhaps Mr. Ho is too impatient and he has not waited for this discussion, but rather he has come up with a motion which is to be raised on the 9th of May. And from Mr. Ho's letter, I can see that a couple of things. One, procedurally, this panel should have made the discussions on this topic first and then make the relevant arrangements. I mean, theoretically, that step should be made rather than to jump to the step of proposing a resolution. That's the first point. Secondly, Chair, you have mentioned just now very clearly that for members' motions, the rules of the LegCo has some very strict requirements, and that is we should not engender, these motions should not engender public money being spent. My question is, by so doing, Mr. Ho, by coming up with a member's bill, would that contravene this requirement of the rules of the LegCo? So I just want to be clear about the rules and also about the procedures. Allow me 10 more seconds, Chair. I just want to be clear about procedures and the rules because I do think that this panel should do the discussion, and then the government should raise this as a motion afterwards. I think that would be more appropriate. Yes, our legal advisor, would you want to provide your opinion? As for public expenditure, actually it is under Section 31 concerning charging effect, and bracket 1, it says that a motion or amendment, the object or effect of which may, in the opinion of the President or Chairman, be to dispose of or charge any part of the revenue or other public monies of the Hong Kong shall be proposed only by the Chief Executive, A, or B, a designated public officer, or C, a member, if the CE consents in writing to the proposal. And the Basic Law also says so. So that is to say the CE or with the CE consent, can the member propose this? And also, for the charging effect, the President or Chairman will have to provide an opinion on that. Otherwise, the only persons mentioned under A, B, and C can make the proposal. And we refer to precedents. For example, the consideration, would there be lowering of the revenue of the government, or would it increase the expenditure of the government? Would it create new positions in the administration? Or at present, I cannot provide any opinions on this. When you say chairman, you mean chairman of the LegCo, is that right? Correct. All right. We will have to handle the motion. From my experience, you want to speak? Maximum 1 minute, please. Maximum 1 minute. Yes, Chair, because my name was mentioned by Mr. Holden Chow, so I have to speak up. Now, concerning the procedure, on the 26th of March meeting of this panel, I have spoken on whether we should raise this as a topic for discussion. At the time, the government had not responded that there should be discussion in future meetings of this panel on that topic, and therefore I have done what I have done. Mr. Holden Chow, you were not at the meeting at the time in March. If you were there, perhaps you would have done the same. Now, as for the charging effect, I'm looking at section cap 10.45. Well, it is about whether the government indirectly will have to make payments. Well, for this damages for bereavement, the government may have very indirect responsibilities, and the government had, if this is because of government wrongdoing, and only if it is the wrongdoing because of the wrongdoing of the government. So the chances of that is very, very low indeed. I want to announce that we need to extend this meeting by 15 minutes in order to handle the motion. Ms. Lee, you want to respond? Yes, indeed. First of all, on charging effect, it is true that the government may, according to this piece of legislation, have to pay out certain compensations, and it's actually been done. Mr. Wan can perhaps follow up on the details of that payment. As for the amount of damages, it had not been revised since 1997. I understand from perception's point of view, the fact that it's not been revised since 1997 seems so incorrect and inappropriate. But I want to reiterate the point that the CPI had been on the fall since 1997 until 2013, and it went back to 1997 levels. And therefore, in 2014 we had started the process for review. I would agree that we could have been faster in that review process. Now, with the mechanism, every 2 years we will be able to make reference to the CPI and review the bereavement sum. Now, as the legal advisor had pointed out, the chairman of the LegCo will have to make that decision. So I cannot say whether it is one way or the other at this panel. Well, in the past, I have myself experienced many of these motions for amendment. Now, as for the panel, I think at this meeting, we have done the discussion on this topic. And so what we have to do now is to handle the motion proposed by Mr. Holden Chow. Yes. Do we need a quorum for this? Please, you can spend 1 minute to explain your motion. Chair, this is the panel is concerned about the 4(3) of the bereavement sum under the Fatal Accidents Ordinance, and it had not been revised. The damages had not been revised since 1997, and the panel urges the government to, within this legislative year, to propose the resolution to, as soon as possible, increase the damages to 220,000 Hong Kong dollars. Let's put this to the vote. All those in favor, would you please raise your hand now? I can see that this is unanimous among members who are present here. Yes, I will ask the question. Are there any objections? No? All right. The motion is carried. The government, within this legislative year, on behalf of this panel, will propose this motion. And apart from that, concerning the increase, can it be not just take reference from the CPI every 2 years? That is too slow, and it would not be in keeping with the inflation situation or with the economic situation in Hong Kong. So do think about the feasibility of that opinion. Yes, this is the end of the meeting. Thank you for coming to the meeting. Thank you.